mother's parental relationship, but it will affect the relationship with now the deceased father's relatives. But we're going to look at those nuances as we go along. So states still kind of vary a little bit, okay? In light of diversity and the complexity of kind of modern families, the fact that we have different types of families with adoption, multiple marriages, single parents, unmarried domestic partners, states are kind of having to look at these issues a little bit again where they haven't looked at them for years. Okay? So we just talked about Maryland having no dual inheritance. But in Texas, for instance, it's still law that an adopted child can inherit from both adoptive and natural parents and their relatives. So in Texas, you could be adopted and still inherit from your genetic parents' family. Okay? And what you see in those cases, by the way, as we'll talk about, is even if there's adoption down from genetic family to the child, generally there's not inheritance down. Generally there's not inheritance back up, meaning that even if you allow the adopted children to inherit from their genetic family, typically the genetic family cannot inherit from the now adopted child. That makes sense to everybody? Okay? So it's going to cut off at least inheritance one way.
Is that because the adoptive child has been cut off from any inheritance they would have received anyway? Or do I adopt a independently wealthy child for whatever reason?
Right. I think the reason that they don't allow, in some instances, the now adopted child, if they somehow die, to have their assets go back to genetic family, is because they are considered to be in a different family now. But it is. We're going to allow them still maybe to inherit, but not the back way. We're going to look at the UPC approach in more specificity today. Okay. In Nebraska, for instance, we recall the statute. They clearly state an adopted child is the child of an adopting parent and not of the natural parents, with the exception that adoption by a child of the spouse of a natural parent has no effect on the relationship between the child and that natural or genetic parent. So again, dealing with those divorce situations, the automatic adoption or the adoption now by a new parent is not going to sever any relationship with the genetic parent who they've married. Okay. Here's a weird case that I found in Nebraska, which I just thought was interesting. Never really thought about this issue, but I'll just throw it out there. It's a 1980 case, came out of the Supreme Court here. A twice adopted child. So they were adopted and then adopted a second time. It can happen. Okay? Twice adopted child cannot inherit under the rules of intestacy from his first adopted parent who agreed or consented to the subsequent adoption and relinquished all their parental rights. So that's going to kind of be the linchpin I think you need to look at in most instances. Is there a relinquishment of the parental rights? And once that happens, in the vast majority of states, that's going to cut off any inheritance rights between those two sets of individuals. Question? Yeah?
Does the same go for termination?
Right, so either voluntary or consented to, or non-consensual, where a court basically severs their parental rights for any number of reasons, right? They're in prison, prison doesn't automatically do it, but it if you have some fairly repeat offenders back in prison on drug and other types of problems, and these children have been in the system for a while, they're just going to have to terminate their parental rights in order for that child to have some sort of family life. So you're going to see that from time to time. Yeah. Correct. So if you sever the parental relationship, the parent-child relationship is the way the UPC calls it, then there's not going to be inheritance back to the no longer parent, for lack of a better word. Right, and in most states there'll be no inheritance from that genetic parent who's had their severed rights down to the child either. Yeah.
I guess my question is going forward then. Back in the day when they did this case, kind of the traditional rule was if there was a divorce or swear up the names of the kid and eliminate the, a lot of the bastardy situations or whatever. But now, in the modern era, generally that formality adoption doesn't take place when families blend. And so, how does that work for kids that are essentially, the child of somebody, but actually are never adopted? How does that affect their ability to inherit,
Right.
say, a stepdad or whatever?
When we look at the UPC anyway, what you're going to find is they're not a child, or they're not considered a child of, even if they're living in the home with what is essentially a step-parent, they're not legally anything. And so, unless they do something to legalize that relationship, they are still connected to their biological or genetic parent who's not in that relationship. So, again, if you're talking about a remarriage, let's say of the mother, she has custody, she remarries, and it's very common, the new husband can't adopt the children because the genetic father is still alive. And just because he's divorced doesn't mean he automatically loses his parental rights. So vis-a-vis the new parent they're living with, that new father, I use father in quotes, there is no legal relationship, at least under the modern approach. And something's got to be done for them to inherit from him.
Well, then I guess to take it one step further, sorry.
That's okay.
When we were talking about spousal share,
Mm-hmm.
right? So stepdad dies, and we've got this blended family now. Are the natural children of the deceased father able to claim more of that share, or does the spouse then get to devise everything that was left?
Okay, so you have
So
genetic fathers passed.
yeah, we've got
Right.
We've got stepdad, biological mom, 6 kids, 3 from mom's first marriage, 3 from marriage with dad.
Okay, so she's now had 3 more children with the new husband.
Right.
Okay, so it's not Brady Bunch. Okay,
All right. So no mom. But
start singing.
so stepdad, dad dies, but leaves all of his share to the spouse.
Right?
Right, to take care of the children. When she dies or distributes or whatever, is she under any higher obligation to his biological children than her own?
It's a good question. No. And that's something, did everybody understand his question? Everybody there? Okay. If we have, husband 1 dies, wife has 3 kids with him, husband 2 comes into the picture, she has another 3 kids. So you have A, B, C, D, E, F. Okay? Husband 2 dies, everything goes to the wife, which is the typical estate planning technique. It's now her money. So she's under no obligation to leave more for D, E, and F than she would for A, B, and C. Now, you might say, well, morally that doesn't seem correct because some of the money is from H2. That's why H2 would need to do a little bit more sophisticated planning. He might want to go ahead and set up a trust for D, E, and F that give them some assured money separate and apart from A, B, and C. Am I answering your question?
Yeah.
Right. That's why default rules are great, but if they don't fit, you're going to have to do your own plan.
What if you have a TPR situation, but those kids are just tossed into the system, go through foster care, and they're never adopted by someone? Just SOL? Congrats.
I'm trying to think of another acronym I can throw in there.
Simply out of luck.
I don't know. They are out of luck. So if you have a child that just is never adopted, which is sad, right? Then they still have, there's no legal, right? There's no termination of parental rights. And so they're, unfortunately, probably linked to a family with no money. Again, so I have an adopted son, but for many years I was trying to adopt in the domestic system. We saw all kinds of kids in that situation, right? And in those situations, the only thing you can hope for is that even though mom and dad, and sadly most of the kids in the system have parents who have, they have criminal records, but a lot of it's due to just, drug and alcohol abuse, just really rampant drug abuse. So those kids, the best you can hope for is that there's grandparents, aunts, uncles, or somebody else who will at least take them at some point or they can maybe inherit from.
Well, I'm talking about the kids that parental rights have been terminated by the state and now they're in the foster care
Oh,
system.
okay, I'm sorry, right. So they've terminated parental rights, but
Right.
then,
And they're just
It's a
stuck
good
in the
question.
system. Maybe it's a problem child that no one wants to adopt.
right, or they're too old, right, old
But
being in
yeah, they
quotes.
moved out the system.
So let me, her question, which I misunderstood or didn't listen to correctly, was that if they have kids in the system, being that they're in the foster care system and their parental rights have been severed because, or terminated because, again, typically the parent's probably incarcerated with severe drug problems, things of that nature, those kids are, to quote, SOL because they have no one to whom they're linked legally. And I think that's the right answer. I can't think of any variation on that rule, unfortunately, which is really tough. Yeah, that's why it's such a sad tale if kids are not somewhere along the way, if they're not adopted before they're emancipated. Yeah.
I'm guessing that, even though it's sad, like, most times in that situation, it's not gonna be anybody inheriting. Like,
Probably not. You're right. And if there were family capable of caring for them, they had long ago been contacted. Right. Yeah. Boy, I don't teach family law, and it's not my area, but I'll say, just from working in the Delaware system, and then I volunteered in the system for a while too. It tends to be that even relatives close to them, sometimes they're not capable because it's a whole socioeconomic. It's just, they've been hotlined when they watch the kids, so it's a mess. It really is. Okay. But I will say that, supposedly the amount of kids in the foster care system in this country is at an all-time low. In part because foreign adoptions collapsed, and a lot of the programs have collapsed, and what you found is that there's a lot more domestic adoption that's happened. Even of children with potential quote-unquote issues, right? People will look past those and say this is the time to step up. So that's a whole other discussion, but it's a very interesting one to have. Okay, so where are we? Let's look at the UPC. Sorry, I'm just having all kinds of problems up here. What's going on? Oh, God, this is a nightmare. Okay, you guys can have a good laugh. Here, what else can I do? Set it down. Okay, let's turn to, I'm in the supplement. Let's look at the UPC provisions. Okay, and I'm on page 38. Let's look at 2-119. So when I start talking about the UPC, and you see that I have 2008 amendments in there, those are the most recent round of amendments that the Uniform Probate Code has adopted. And there was a great question after class the other day, so let me be clear again about the fact of what a Uniform Act is. It's similar to a model act. It's just two different drafting bodies. So if you're not familiar, model acts like the Model Business Corporation Act tends to come out of the ABA, American Bar Association. The Uniform Acts tend to come out of what we call an accusal, the National Council, I forget what it even stands for, but it's a National something Council on Uniform State Laws. An accusal has committees for each different act, and it's comprised of practitioners, academics, and judges. And so they're the ones drafting it. The hope is you put out a new round of amendments to the UPC, and then the states consider those, and someone then, in Nebraska for instance, has to pick up those amendments and say we need to update our probate code and have a legislative act, right, to incorporate the new changes. So we look at it because it's uniform, and it's supposed to give each state a model so that we can talk about these issues and hope that there's a lot of uniformity between the states. And in a lot of the things we're looking at, there is uniformity. But it doesn't mean that states automatically have to adopt any new changes. And in fact, some states have not. Some states haven't caught up with the 1990 changes. So the 2008 changes clearly are very new, and at least if you think about how long it takes for law to change. So we're going to look at them again because that's what the most current provisions are. But I can't say that you're going to see a lot of those in place at this point yet. Okay. So I'm down at the page, bottom of page